For the record, this matter is before the court at the request of the plaintiff, Christopher Sindoni, complaining that he's not receiving the parenting time previously ordered by this court. This hearing is being conducted via Zoom. It appears that both parties are present. So you're Christopher Sindoni, is that correct?
Yes.
And ma'am, you are Jennifer Sindoni, now known as Jennifer Newman. I'm sorry, now known as Jennifer Victory, is that correct?
Yes, Your Honor.
All right. Mr. Sindoni, you are still incarcerated. I believe we're in the Upper Peninsula.
No, it's St. Louis, Michigan. It's in the middle of the state. The middle of the Lower Peninsula. Yeah.
And when is your scheduled out date?
It's Christmas Eve of 27. I'm still doing appeals though, Your Honor, and it's due any time. So I don't know.
Okay, your out date is 2027, is that correct?
Yes.
Of course, your children will be adults by then, and they can do as they choose. Right now, your children are their 15-year-old twins, is that correct?
Yes.
Mr. Sindoni, Miss Victory, are the children right now, they're 15-year-old twins, is that correct?
Yes, Your Honor.
All right. The court's last order, entered on June 10th, 2022, is that parenting time shall continue as previously ordered. We're back on a similar request of Mr. Sindoni. The court ordered that father shall have video parenting time with children once per month. Father shall pay for the session. Once mom receives payment, she'll initiate the video call for the children. The court denied the request for in-person parenting time. The court's going to continue to deny that, Mr. Sindoni, if that's the request. It's just a matter of the court believes that we should continue what's previously ordered. That is the video contacts with the children. So, Mr. Sindoni, what's the problem? What's the issue?
I've paid for the visits already, and it's on her to schedule them because they're minors. They're not allowed to. She has to do it. Of the 30, there were 38 visits that I paid for. She owed me $10 for some other thing. She said she would pay for 3 additional visits. Of the 41 visits, there's been 16 of them scheduled. But of those 16, only 5 have actually taken place because she checked the children into it. And I need my visits. I'm 3 years behind now. I've already paid for 3 years of visits, and this order was 3 years ago, and I haven't gotten 3 years of the visits that I've paid for.
Okay, the court, rather than look back, the court like to move forward and get back on track. Miss Victory, I understand the children are 15, but they're still minors, and you need to make this happen, even if it's only for a couple minutes. They need to at least say hello to their dad or talk to their dad. If they don't want to say hello, they got to say, they at least got to look at them.
And Your Honor, and that's what they're doing. Is they don't want to speak to him. Every time that we have a visit with Mr. Sindoni, he is screaming at my children. You have to talk to me because the judge said so.
That's not true, Your Honor.
No.
All right.
I'll get the visits.
Okay, I guess you can tape them then, Miss Victory. If in fact he's yelling at them, it's inappropriate, then obviously they should be terminated. That should not be appropriate or necessary, and that's certainly no way to encourage the children to have a meaningful discussion with their dad if in fact you are lashing out against Mr. Sindoni. So let's get back on track. Has he paid for some visits?
He's paid for some visits. However, Your Honor, my children are not
sent you $80.
Mr. Sindoni, hold on. Don't interrupt. Let Miss Victory finish, and then I'll let you respond. Miss Victory?
Your Honor, yes. Mr. Sindoni has sent me $40.
It's been $80.
You've sent me $40. And of that $40, very minimum of the visits have been scheduled, Your Honor, because that's all Mr. Sindoni does is scream and yell at my children and say that because you're the judge, you said that they have to talk to him. Okay. So therefore, I have ended up leaving the meeting because of him screaming and yelling at my children. This is not okay, Your Honor. This is a very toxic situation. Mr. Sindoni,
The reason it's toxic is because of
Hold
you,
on,
Jennifer.
hold on, Mr. Sindoni. Please let her finish, then I'll let you respond. Obviously, it sounds like it's toxic, and the two of you can't communicate. So, Miss Victory will finish up, and then I'll let Mr. Sindoni respond.
Yeah, Your Honor, these visits honestly need to stop because my children refuse to speak with him because of his tone and his demeanor and how he's treating my children. And I can get the video visits to prove it.
Your Honor.
Well, let me, one last question. Has Mr. Sindoni sent you money that's not yet been used for the video contact? Because it does, there
probably,
is
but not very much. Like I said, Your Honor, he has sent me $40. So if Mr. Sindoni really wants that money back, I will gladly go ahead and pay him the $40 back that he sent to have video visits. So that way we can be done with this because they refuse to talk to him.
What is it? No, we're not going to be done with it. What is the cost of each video contact? $20, $10?
$3.25.
Yeah,
$3. Mr. Sindoni, please stop or I'm going to mute you. Miss Victory, how much are the video visits?
$3.20 a visit for 15 minutes.
So you acknowledge you've got $40 that you're holding for future video visits, correct?
I have used part of that money for some of the video visits. However, not all of it has been used.
Okay, well,
because
how much?
I didn't want to waste money.
How much do you have left? $30?
Probably 25 to 30.
All right.
I'll pay him back, Your Honor. I'll put it in his commissary. I have no problem with that.
No, we're going to do some more video visits, Miss Victory. What I'm going to suggest is you videotape those, and if in fact they are inappropriate, you scream at them, then the court will terminate the visits.
Okay.
It's none of that.
Okay, Mr. Sindoni, Mr. Sindoni, now it's your time to respond, Mr. Sindoni.
I'm sitting there in the visits and I get my daughter telling me how I beat Jennifer and choked her and all these lies that she has told them that never happened. It never happened. We've already discussed this in the past in the court. And you told Jennifer to stop telling this to the children. So every visit, it's the last visit, for example, Jennifer tried arguing with me. My daughter told her to shut up. It's her visit. Then my daughter's accusing me of doing all this stuff that I never did. So I'm telling her that never happened, Chloe. Chloe got upset. Jennifer deleted into the meeting, but I wasn't screaming at my daughter. And
well, that's
some of the visits that do happen. They just stare at the camera.
Perhaps when your daughter's upset and she's screaming at you, making accusations, that's when you sort of delicately just change the topic and say, tell me how are you doing? How is school? What's your favorite subject? Are you playing any sports? You have some constructive discussion as the adults, Mr. Sindoni. There's ways you can handle that to distract them from some accusations and say, that's not what we're here to talk about. What's ever happened in the past, we're going to put in the past. I'm just saying I'm here to talk to you because I love you. You got to make some positive comments. There's ways you can address that to make the children more comfortable, Mr. Sindoni.
And it's okay for Jennifer to tell them that their last name is disgusting and they can change it to her new husband's name. And this is part of the arguments too, No,
so
you're basically telling them that they're disgusting.
Miss Victory, please stop talking over each other. Let the other person respond. Mr. Sindoni, in answer to your question, no, it's not appropriate she tell him that, but how do you know she's telling him that?
Because they're telling me that, my last name's disgusting, so they want to change it to her new husband's name, and all. They wouldn't even know that unless she told them they can do that.
Well, you're assuming
just
that.
Like she told them, just like she told them that the judge said they don't have to visit me if they don't want to.
That's not true. The judge has never told them that. They are minors. They are minors. It's not. They don't drive the bus in this Victory. They're minors, so you need to make this happen. You need to encourage to have one dad in this world. Okay, maybe there may be a relationship that's difficult and estranged right now, but hopefully that can be redeveloped in the future. They're going to want a dad in the future. Also, hopefully, Mr. Sindoni, once he's out of prison, he can nurture a relationship. And yes, but they're going to be adults without prison, so that's up to them.
As soon as he gets out, I'm going to have a PPO because
we're done. We're done. I'm not going to argue with both of you. Both of you want to interrupt to the court. and they would not let the court talk. So the court will simply order that parenting time continue as previously ordered. Let's schedule the next, while we're on the record, let's schedule the next video visit. Mr. Victor, you got $25 to $30 you're holding. And let's, we'll talk about one a month. So let's pick a date sometime that's good with the children sometime in the month of May.
And Your Honor, it has been $80. I can get my stepmother who sent the checks to send me a statement from the bank saying that it's been $80 if you want it.
Okay, I'm not going to get into this right now.
Well, she's saying I've only paid for half of what I've paid for. So it is an issue.
Okay.
It is an issue.
Okay.
I've paid $80.
Okay. She's got sufficient funds to do some video contacts. So what day in May are you going to make this happen, Mr. Victory? Is it best on a Saturday morning, or is there certain days that the prison facility will allow video visits?
I'm not sure.
Yeah, it has to be done through a certain app. I can do May 18th.
Okay, that's a Saturday.
Yep.
Well, I don't know if that's the visiting day, but okay.
All right. Well, the court's going to order that parenting time continue as previously ordered. Once a month, video contacts. Mr. Sindoni to pay. Miss Victory has the funds right now to at least pay for probably the next 4 to 5 months. Correct?
Yes, Your Honor.
And the visits probably should not last more than 15 minutes.
No, that's all their limit is.
Correct.
So, and then sometimes 15 minutes, sometimes you got to warm up to the children and maybe make some notes, Mr. Sindoni, things you want to ask them, but maybe let's let them talk. Just say, tell them you love them, you miss them. Tell me what's going on in your life. I really want to hear that. Maybe.
They tell me it's none of my business because Jennifer told them that it's none of my business.
Sindoni,
they don't have to tell me anything.
One of the suggestions the court has you talk too much to Mr. Sindoni. Maybe think about listening more rather than talking. That might go a long way to repair relations with your children. Listen rather than talk.
If I ask them what's going on, how's school going, they tell me it's none of my business.
Well, but tell them that you want to know, that you're interested. You love them, you're interested.
I've tried.
Okay.
You got Jennifer in the room with them, coaching them though, so that it doesn't help.
And Miss Victory, they're old enough. If in fact it's something inappropriate and they're Mr. Sindoni's arguing with them, they can step away. But you should give them some privacy. Set it up.
I do. It's
right.
Mr. Sindoni with his accusations that's making you think that I'm doing something that I'm not doing.
That's all the court's asking. All right, so the court's going to order that, Miss Victory, they schedule a video visit with the children together on their dad, May 18th, 2024, and each month thereafter. And once you no longer have any funds left, it's $3.20 for a 15-minute visit.
Yep.
And that should cover you for the next number of months.
Yeah.
And if in fact you run out of money, send a message to Mr. Sindoni. You need some additional money. And Mr. Sindoni, just send maybe $20 at a time. They'll be sending $80.
That's all I've been sending, Your Honor. And I've sent 4 checks to her. Okay.
Well, at this point in time, the court's ordering that Miss Victory make it happen on May 18th. If the prison said it won't do that, then do it the closest to Saturday as possible. But try to schedule it. Go online today and try to schedule for the May 18th. Miss Victory. Okay. All right. So hopefully we won't have to come back in a couple months. But again, the court's going to order continued parenting time once a month, video contact, father's expense, and the next one will be May 18th, 2024. Then once in June, July. And just tell the children, once they're 18, they can do what they want. But this court has jurisdiction and authority over them until that time. So you tell them it's a court order, and we can help Mr. Victory by encouraging it. I know you're shaking your head, but again, you can encourage it. The children, they can do what they want. They can run away from home. They can leave your house when they're 18, but until they're 18, they need to comply with their dad and their mother's rules. So just encourage it, Miss Victory. I understand they may not relish it, but encourage it. Tell them to make life a lot easier on you. Then you'll need to be coming back to court. If in fact you facilitate it, cook it up, have them sit on the couch together, and at least hear out their dad. Please.
Okay.
Okay, the court will reduce this to written order, and that will, anything further from either one of you?
No, sir.
Have a good day, Your Honor.
All right, thank you both. Miss Aaron, are you still there? Good morning. You're muted. Okay, you can hang up, Mr. Sindone. Miss Aaron, could you be kind enough to do a quick order for the court? Oh, Sarah's got you muted.
There we go. So, Sarah, I couldn't unmute. Sorry. Yes, I can reduce that to writing.
That'd be great. Just say parenting time, plans parenting time, shall remain as previously ordered. Father shall exercise video. Actually, I've got an order here. Looks like June 10th, 22. It's going to be exactly the same. The next video visit shall be May 18th, 2022. At least there's some in the file that show that we conferred with these parties.
I'll defer to you. I have no problem.
Okay, I'll do it.
I didn't know you were popping on.
Yeah, I always pop on just in case anybody needs me.
I always need you, Josh.
Thanks, Gina. I appreciate that. I take that as a positive that you need me.
Yeah, you should.
For the record, this matter is before the court. Subsequent to the parties having engaged in mediation with Mr. Walker from the front of the court, this hearing is being conducted via Zoom. Present is Attorney Gina Donnelly. Good morning, Ms. Donnelly.
Good morning, Your Honor.
Ms. Donnelly is representing the plaintiff, Carrie Bergman, apparently now Drake. In addition, Attorney Kirsten Nemec is present representing defendant Eric Bergen. And Mr. Bergman, and Mr. Bergman is present. Good morning, everyone.
Good morning, Your Honor.
The court.
Good morning, Your Honor. May I put my appearance on the record? Gina Donnelly for Carrie Drake, P number 47674.
Thank you. The court has been informed the parties have made some progress in terms of their own agreement regarding parenting time this morning. Is that correct?
That is correct, Your Honor.
Wonderful. And who would like to place that agreement on the record?
We're going to have Joshua Walker of the front of the court place it on the record, Your Honor.
Yes, Your Honor, I can do that.
Please, Mr. Walker.
Okay, the parties have agreed that they are going to share joint legal custody of the minor child. Parties have also agreed that the minor child, Andrew, will start counseling with an agreed upon counselor between the parties. Mother is going to continue using SoberLink. She is going to test every day at 8 a.m., at noon, and at 8 p.m. Mother's parenting time is going to commencing next week. So May 15th, which is next Wednesday, Mother is going to start parenting time every Wednesday from either after school or from daycare to 8 p.m. And she will have every other weekend commencing May 17th from Friday after school or from daycare to Monday to school or from daycare. Mother is also going to get Mother's Day this year, which is May 12th from 9 a.m. to 9 p.m. Father is going to be able to deny mother parenting time if she either tests positive at SoberLink, misses a test, or has a rejected picture and does not retake the test with a good picture. If either of those three occur, then father is able to deny parenting time at that time. The parent parties have also agreed that they are going to refer the issue of whether or not Kenneth Wolfram will be allowed to be in front or in the presence of the minor child. They're going to refer that to the front of the court for an investigation and recommendation. In the meantime, Kenneth Wolfram will not be in the presence of the minor child. I believe, Your Honor, that is the extent of the agreement for today. There's going to be another mediation scheduled for July 1st at 8:30 in the morning with myself.
Thank you, Mr. Walker. This investigation of this third party being present with the children, who will be interviewed? Just the parents, or are we going to interview this, put this 10-year-old child in the middle?
Just the parents, Your Honor.
All right. Is that correct, Ms. Nemec, Ms. Donnelly?
It is.
Your Honor,
Right.
Your Honor, my client was under the She's under the opinion that her child is mature enough and old enough that the front of the court person who's probably been trained in forensic interviewing can interview this minor child and see what his wants or wish can be. I don't think it'll be a matter of, having him in the middle of it. I think it's just a matter of what his opinion would be. And as I stated, I believe we do think that he's mature enough and old enough to give his opinion.
Well, it may be, but I mean, no child likes to be interviewed by third parties in front of the court. I mean, yes, the parents put that child in the middle when they have the child interviewed by a front of the court caseworker or even the court. So, Ms. Nemec, what's your position on that?
Your Honor, Mr. Bergman would prefer that the minor child not be involved at this point. He doesn't think it's necessary. Also, the minor child, part of the reason that the parties have agreed to counseling for the minor child is because he has been exhibiting some anxiety over these proceedings. I think asking him to participate in an interview with friend of the court would only exacerbate that anxiety, and I don't see any benefit to it.
All right, the court's going to leave that to the front of the court. The discretion of the front of the court. The court's confident it's the front of the court. I don't know if Ms. Ms. LaPrade will do that interview or whether it's Ms. Scott, but the court will leave it to that front of the court caseworker who conducts the investigation to determine whether or not, after interviewing both parents, whether or not the 10-year-old child needs to be interviewed. So with that having been addressed, Ms. Donnelly, did Mr. Walker accurately state your client's agreement?
Yes, Your Honor, he did complete. It was full and complete.
Thank you. Ms. Nemec, did Mr. Walker accurately state your client's agreement?
Yes, he did.
All right, Ms. Drake and Mr. Bergman, will you both please raise your right hand to be sworn, please?
Okay. We come here today based on your motion, and we've come to a reasonable agreement partially. You've heard the agreement that Josh Walker placed on the record. Is that your understanding of the complete and full agreement as of for today?
Honestly, I had trouble connecting, so I got in right at the end, but I have every faith that what we discussed in the breakout room is what he said, so yes.
Okay, thank you. Also, have you been coerced to enter into this agreement?
No.
Has anybody threatened you to enter into this agreement?
No.
Okay. And so it's your understanding that you would like to have the court enter into this agreement today?
Correct.
Thank you. Have nothing further, Your Honor.
Ms. Drake, do you believe this agreement is in the best interest of your son as of this point in time in his life?
As of this point in time in his life, yes.
Thank you. Ms. Nemec, do you have any questions, Ms. Drake?
I do not. Thank you.
Questions for Mr. Bergman, please.
Eric, can you state your name for the record?
Eric Stephen Bergman.
You participated in mediation with Mr. Walker this morning, correct?
Correct.
And as a result, an agreement was placed on the record.
Correct.
You heard the agreement as Mr. Walker placed it on the record?
I did.
Was it accurate and complete?
Yes.
Did you participate in coming to that agreement?
I did.
Did you have time to think about it?
Yes, I did.
Did you have time to discuss it with me?
Yes, I did.
Is anybody forcing you to enter into it?
No, they are not.
At this point in time, do you believe that the agreement that you're entering into is in Andrew's best interest?
Yes, at this point in time, Andrew and Eric's best interests are being looked after.
Okay. I have nothing further, Your Honor.
Thank you, Ms. Nemec. Ms. Donnelly, do you have any questions of Mr. Bergman?
No, sir, I do not.
Very well. Who will prepare the order?
I will.
All right. Thank you, Ms. Donnelly. Very well. The court would like to thank Mr. Walker for his assistance this morning, as well as, of course, attorneys Donnelly and Nemec for helping facilitate amicable resolution. The court would applaud you, Mr. Bergman, Ms. Drake, for reaching your own agreement, taking one step at a time. And the two of you know what's better for your son than anyone in this world, including the court. So really, these decisions should be made by the two of you working together for his best interest rather than the court making these decisions. But the agreement that the two of you have reached this morning, the court finds that to be the best interest of your minor son. The court will accordingly adopt the agreement, enter the order upon presentment, and we will see everyone after the July 1st, 8:30 mediation. So if you can put that date of mediation in the order, Ms. Donnelly, and just indicate
Yes,
the
sir, I
parties
will.
appear subsequent there too for review.
Yes, sir, I will.
Right, that will conclude this hearing. Everyone can zoom out. Have a good rest of the day. Ms. Drake is present. Good morning, Ms. Donnelly.
Good morning, Your Honor.
Morning.
In addition, Attorney Kirsten Nemec is present, representing defendant father Eric Bergman. Mr. Bergman is present. Good morning, Ms. Nemec.
Good morning, Your Honor.
The parties were to review issues of parenting time, custody. There's I believe, 3 or 4 issues that were addressed. Did the parties make progress in terms of temporarily resolving those issues? Ms. Donnelly, Ms. Nemec?
They have made great progress, Your Honor. And I'm glad to say that Mr. Josh Walker is going to place the agreement on the record for us.
Not sure if Mr. Walker is still available. Oh, there's Mr. Walker. Good morning, Mr. Walker.
Good morning, Your Honor. I can put it on the record if the attorneys would like me to.
That's fine. Mr. Walker, if you don't want to, I can put it on the record, but I'm fine with you doing it as well.
Yeah.
Okay. All right. When Your Honor is ready, I can go ahead.
Okay, yes. Whenever you're ready, Mr. Walker.
Okay. The parties have agreed that plaintiff will continue using SoberLink at this point in time 2 times a day, once at 8 a.m. and once at 8 p.m. With the same provisions as the previous order regarding what happens if there's a positive result or a rejected picture that is not retaken in a timely fashion, or if a test is missed. As long as everything goes smoothly until up until December 9th, then Ms. Drake will no longer have to use SoberLink as of December 9th. That's when it will end. The parties have agreed that they are going to adopt the front of the court recommendation regarding Kenneth Wolfram, stated June 26, 2024. They will adopt that in full.
I'm sorry, what is that? Is there a restriction, Mr. Walker? Is there a restriction on this third party from being present during mother's parenting time? Is that correct?
Yes, that is correct, Your Honor. At present, Mr. Wolfram is not allowed around the minor child. However, the front of the court recommendation will allow Mr. Wolfram to be around the minor child during Ms. Drake's parenting time, except for overnights, until November 1st, when overnights with Mr. Wolfram will be allowed.
All right, thank you for that clarification.
You're welcome, Your Honor. The parties have also agreed that they are going to start using app Close for all communication. And Mr. Bergman is going to set up an account and send the invitation to Ms. Drake so that they can set that up and start using app Close. The parties have also agreed that the minor child Andrew will have access to his cell phone at all times so that he can communicate with the other party during one party's parenting time. And the parties, last of all, have agreed to a continued mediation on February 3rd, 2025 at 8:30 a.m. to review parenting time. I believe that is
what's that date again? What's the date again, Mr. Walker?
February 3, 2025 at 8:30 a.m.
Thank you, Mr. Walker. Ms. Donnelly, did Mr. Walker accurately state your client's agreement?
He certainly did, Your Honor.
Thank you. Ms. Nemec, did Mr. Walker accurately state your client's agreement?
Yes, he did.
Well, Ms. Drake, Mr. Bergman, can you both raise your right hand and be
You
sworn,
heard
please?
the agreement that Mr. Walker placed on the record?
I did.
And is it complete?
It is.
Is it your understanding that this agreement will be in the best interest of Andrew, your minor child?
It is.
And have you been coerced into entering into this agreement?
I have not.
Have you been threatened in any way?
I have not.
Have you been promised anything?
No.
So it is your understanding that you would like to have, or you would like to have the court adopt this agreement?
Yes, it is.
Okay, and again, because it is in the best interest of your child.
Absolutely.
Okay, I have no further questions, Your Honor.
Thank you, Ms. Donnelly. Ms. Nemec, do you have any questions, first of all, for Ms. Drake?
I do not. Thank you.
Questions for Mr. Bergman, please.
Eric, can you state your name for the record?
Eric Stephen Bergman.
And you heard the agreement that Mr. Walker placed on the record this morning, correct? Was it accurate?
Yes.
You engaged in mediation this morning, and the result of that mediation was that agreement.
That's correct.
Is anybody forcing you to enter into the agreement?
No, they are not.
Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Do you believe that it's in Andrew's best interests?
Yes,
Do you know that we could have taken this matter to a hearing and the result could have been different?
I do.
But rather than do that, you're asking the court to take this agreement that you've worked out through mediation this morning and make it an order of the court.
That is correct.
Do you have any questions about any aspect of that agreement?
At this time, no.
Are you satisfied with my representation?
I am.
I have nothing further, Your Honor.
Thank you, Ms. Nimick. Ms. Donnelly, do you have any questions for Mr. Bergman?
No, Your Honor, I do not.
Very well. Who prepared the order?
If Ms. Nemick would be so kind,
I can do
I'd
that.
appreciate it. Thank you.
Okay, thank you, Ms. Nimick. The court would like to thank and acknowledge Mr. Walker for his fine assistance this morning, as well as, of course, attorneys Donnelly and Nimick for helping the parties reach their own agreement. The court finds this agreement to be in the best interest of the minor child. The court will currently adopt the agreement and the order upon presentment. And we'll put it in our calendar to review this matter subsequent to the parties' continued mediation with Mr. Walker on February 3rd, 2025 at 8:30. If you can put that date in your order, Ms. Nimick, to indicate that the parties will mediate with Mr. Walker on that date and time and subsequently appear before the court for review.
I will do that.
All right. That will conclude this hearing. You can all zoom out and have the rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.
Thank
Welcome.
you, Josh.
Thank you, Joshua. Thank you, Kirsten.
Okay, everyone can zoom out. Have a good rest of the day.
Thank you.
Sir, could you please state your name for the record?
Chad Brockway.
Thank you. For the record, Mr. Brockway is appearing via Zoom this morning from the Monroe County Jail. Also present for the Zoom hearing is the Monroe County Friend Court Attorney Rebecca Hicks. Good morning, Ms. Hicks.
Morning, Your Honor.
Brockway, are you being held in jail on any criminal charges?
They got me for a retail fraud thing I just went to court for, I think, if that's what you're referring to, other than the child support. Yes.
Okay.
Yes.
So what kind of bond do you have in the retail fraud charge?
PR bond.
All right. All right. Mr. Brockway, can you please state your current mailing address for the record?
44.
Mr. Brockway, the court file reflects an address of 1200 Union Street. You have an obligation to keep the court informed of any change of address. When you move, you inform in front of the court of your change of address, and your notice to appear for review is mailed to your old address. You appear, bench warrants issued, it's on you.
All right. Sorry,
So
sir.
as soon as you get released from jail, you need to come over and fill out a form, change your address.
Absolutely.
All right, Ms. Hicks, can you provide the court with some background information on each of these two cases involving Mr. Brockway?
Certainly, Your Honor. The 2003 case with Miss Melissa Valade is an arrears only case. The current balance is $4,583.76. The last payment received was July 25th of 2022. That had come from income withholding to from his employer. We do have a previous finding of contempt. It's from April 25th of 2022. It is a first finding and there is a 38-day balance. On the 2019 case with Erica Brockway, that one has a current monthly support obligation of $333 per month. The current balance on that case is $14,920.10. The last payment received on that case was November 16th of 2022. We also have that same first finding of contempt from April 25th of 2022 with a 38-day balance.
You understand all that, Mr. Brockway?
Yes.
You got 38 days hanging over your head. Are you currently employed?
I'm not. I mean, I try to do stuff on the side. I have some current health issues. I have a stage 2 kidney failure right now, and I have some cardiovascular issues. So it's hard for me to work or even talk and walk for extended periods of time because I get real dizzy and lightheaded. So it's kind of hindered me from that. I mean, I do provide for my son. I just don't do it through the courts, which I should stop doing. But I take my son to places, I pay for his classes, I buy his school clothes. You know, when I do work, I try to do what I can for my son. But unfortunately, I don't do it through the courts, and it doesn't reflect on me for that.
Right. So you get no credit for that unless you can convince Ms. Brockway and Ms. Blade to come in and waive some of those rearages. But
Yes.
Mr. Brockway, when you are unable to work, you need to contact the front of the court. You're sitting on your hands. You're letting this issue fester. Right now,
I'm sorry.
Hold on, Mr. Brockway. This 2019 case, it's adding up to $333 every month. and you're sitting on your hands doing nothing. You have almost 15,000 arrears. The Attorney General is going to be knocking on your door real soon, charged you with felony non-sport, for which you can go to prison. They have medical facilities in prison, Mr. Brockway. You're a candidate for prison. Those kind of arrearages. You are lucky that you're not on their radar yet, but you soon will be. So you need to take action. You need to file a motion to reduce your support in that case. And you need to find a job. Unless you're 100% disabled, there are jobs you can do. You can sit at a clerk at a gas station, sitting in a booth. I mean, there's something you do that you can stand up, you can sit down. It doesn't require any physical work. The court will not accept your suggestion. Well, I can't work. There's a lot of opportunities out there, Mr. Brockway. In front of the court is a 4-page list of employers that are screaming for employees, good paying jobs.
Yes, sir.
So this is where we reach out to family and friends to post a cash bond on your behalf, Mr. Brockway. Okay. Reach out to family and friends. Who do you live with? Who's supporting you right now?
I don't. I stay with my girlfriend, and I get state aid. So I'm sorry.
Okay. So your girlfriend is supporting you. So she's putting a roof over your head. She's feeding you. So you need to reach out to your girlfriend to post a bond. Ms. Hicks, what's your recommendation this morning?
Your Honor, my recommendation is for 10 days immediate jail credit for the 1 day he has served, or $1,000 on the 2019 case, or $500 on the 2003 case, with the same jail sentence in each.
Mr. Brockway, is there anything you want to say before the court imposes this sentence?
No, sir.
Okay, so on each of these cases, the court's can already serve 38 days in Road County Jail as follows: 18 days immediate. You're given credit for the 1 day you serve. So that means you're served the next 17 days in jail, but you can be released today, tomorrow, Saturday, upon posting a $1,000 cash bond in the 2019 case, and a $500 cash bond in the 2003 case. $1,500 total, and you'll be released from jail. Now apply 100% your arrearages. You're not going to court costs or fines. They're going to 100% reduce your arrearages. And again, when you get out of jail, you come over in front of the court, you fill out a form, change your address, and file a motion to give you a packet. They give you a form motion to reduce your support in the 2019 case. Right now, it's clipping along. You can't retroactively reduce that. You can only reduce the future support. So you need to reach out to your girlfriend, have her get $1,500 together, go to the front of the court and meet with the caseworker, file a motion to reduce for it. We'll even give you a fee waiver if you can't pay the filing fee. We'll waive the filing fee. Mr.
Yes, sir.
Brockway, you've got to get off your hands and then take some affirmative action. You can walk across the street from the jail to the courthouse, correct?
Yes.
You can fill out a form. You can talk to your caseworker. So that's the sentence: 38 days in jail, 18 immediate. And again, even if you serve the full 18, you still got 20 days hand over your head.
So
you understand that you hold the key to the jail, Mr. Brockway. So the next time you pick up, you're going to serve the remaining 20 days, and we'll start over again in another 45 days. So, Mr. Brockway, be smart. Be smart. Reach out to your girlfriend, your family, friends. Get that money together. That's in your best interest.
Okay.
And you can reach out to Miss Valade and Miss Brockway to see whether they'll waive arrearages because you've bought clothing for the children. If that's true, maybe they will assist you in that regard. Do you have any questions?
No, sir.
Finally, we're going to give you a date for review. We're going to give you a date to appear before Ms. Hicks for review. A copy of the order will be sent over to the jail. Ms. Hicks, what do you suggest for review dates?
July 16th at 8 a.m.
So, Mr. Brockway, you've got to appear before Ms. Hicks for review July 16th at 8:30. You need to provide us a letter from a physician that you're 100% disabled. Otherwise, you need to start making payments. Find it.
Absolutely,
get the 4-page list of employers. Go through this list of employers. There's perhaps something you can do. Otherwise, you need to be filing an application for Social Security and show a medical letter from a physician that you're 100% disabled. Otherwise, you need to secure some employment, Mr. Brockway.
Okay.
Okay. If you have no other questions, you can step out, sir.
Thank you, sir.
Welcome.